This is not your average sentencing hearing. In just a few minutes, you're going to watch a defendant who walks into court already admitting she popped positive for meth today. A judge who's not buying the "I only use under stress" defense, and a legal twist where a plea to simple possession collides. With drug weights and packaging that look a whole lot like distribution, the stakes: 6 years in prison, a possible therapeutic community placement, and a narrow pathway called shock probation, a second chance, that only opens if she proves she can follow every rule on the inside for 180 days. But before we get there, the judge is going to drill down on why there was a scale in her purse, why the lab says 27.459 grams, and why the story of "I'm just a heavy user" doesn't sit comfortably with the Paris Hilton makeup bag containing meth, baggies, and a vacuum-sealed package. Question for you right up front. Does admitting fresh drug use before sentencing make her more honest, or simply demonstrate she can't stop without structured custody? Keep watching, because by the end, you'll see how the court balances addiction, public safety, and parental responsibility, and whether transparency actually helps her or...
All right, are we here for sentencing?
I believe so, Judge. We had reset it for a couple weeks for sentencing only. I didn't know if that meant there would be a TAP evaluation or not, but apparently not. So,
Well, on this case, it would be, I think both parties agreed to provide the court with a IC.
oh, well, I guess that would be the state, because I certainly don't have access to that.
Yeah. Because I believe that the state is silent.
Correct. If I'm not mistaken, Judge, your history is some misdemeanors. Sure. We want to get confused.
All right, court is calling 2024 CR 5145, State of Texas.
We've got our framework, count to only possession, for 200 grams. That's a serious felony range. The punishment cap is 6 years, and the state is silent on her deferred adjudication application. Translation: the prosecutor isn't advocating either way on whether she should get that second chance. Non-conviction track, but silence doesn't equal support. Meanwhile, the judge has already asked for the criminal history and is clearly poised to examine it. Here's the tension. Deferred adjudication could keep a conviction off her record if she completes probation. But the weight, the packaging, and a positive drug test on sentencing day are all about to collide against that request. Question to you: if a defendant pleads to possession but the facts signal distribution-like behavior, should the judge honor the plea structure or sentence based on the totality?
State your name for the record.
Missy Ann Torres.
All right, so you're going to get drug tested today. What are the results going to be?
They will come back positive.
Positive for what?
Methamphetamine.
All right, so how often are you?
This is the kind of moment that instantly reshapes a sentencing hearing. She openly concedes the drug test today will be positive. That's brutally honest, but it's also legal dynamite. Judges read that as a loss of control, not just a bad decision. When she says she only does meth under stress and that the fear of being denied her application triggered her relapse, she's unintentionally proving the judge's point. The stress of court, parenting, and life is exactly what probation requires you to withstand without using. Do you think this honesty should help her, or does it prove the court can't trust her in the community, especially with 3 kids in the picture?
Yes.
How often?
I see them every other weekend, and I don't pay child support, but I pay them. My exes, and I have my daughter. My daughter is with me.
No, you just said your daughter is with the
Yeah,
great
but
grandmother.
I live with my grandmother. This is
All right.
I help take care of her. She
Right.
helps me take care of her.
Okay. So one, I don't think it's appropriate for you to be cleaning houses
Okay.
because of the nature of this offense. And 2, I don't think it's appropriate for you right now to be taking care of your children.
Watch the judge reframe the entire conversation. It's not appropriate for you to be cleaning houses. That's about public trust and access. And not appropriate to be taking care of your children right now. That's child welfare and safety. These aren't punitive throwaway lines. their protective measures flowing from the nature of the offense, her active use, and her own admission of relapse right before court. The defendant asks for outpatient help, but the judge signals custody is coming, and whatever help she gets is going to be inside a highly structured environment. Engagement question. Should active meth users who admit current use be allowed to keep custodial parenting time without court-ordered inpatient treatment? Sound off below.
Well, Your Honor, I was a heavy user back then, and it was.
Oh, you're not, I tell you what, I don't think, and if I'm wrong, correct me. I don't think you were using 32 grams of meth.
It was only 28.
No, you have meth here for 4.964 grams, and you also have meth for 27.459 grams. And what you pled to in count two was a possession 4 to 200 grams. So this is not a possession 1 to 4. So we're talking about 27 grams.
This is the pivot point. The judge hammers the lab confirmed 27.459 grams not. The shaky field test stand focuses on the scale, baggies, and vacuum-sealed packaging. The defendant insists it's all personal use, but think like a judge for a second. Scales plus baggies plus nearly an ounce of meth aren't usually the optics of a stress user. Legally, she pled to possession, not possession with intent to deliver. But sentencing judges can consider the full conduct, including the surrounding facts. Question. Even if the state proceeded on count two only, do you agree that a judge should and can treat these facts as aggravating at sentencing?
459 grams was the net weight of the meth that you had in your Paris Hilton bag.
Yes, Your Honor. And I will say that I used to use a whole ounce within 2 to 3 days. So I was a heavy user, and like I said, they tried to give me half of that the last time, and right now it's going for $250. So if I'm paying $250, I wanted the whole thing. I wanted to make sure. I'm just being honest, and I'm sorry. Excuse me for being.
No, I
transparent.
want you to be honest, and I want you to be transparent.
I'm sorry for being transparent, but it's something that I feel like I worked for my money, and I didn't want just to get gypped again. I can promise you I didn't sell anything. It was because I've been gypped many times. So I did get it. Now it was double bagged because I don't know, that's the way they gave it to me. I can't, and it is my mistake, and I'm taking full responsibility. But
here's where the defendant essentially doubles down. She says she's a massive user, burning through an ounce, roughly 28 grams, in 2 to 3 days. And she carried a scale because she'd been gypped before. That's a risky admission because, while it might explain the weight, it also confirms extreme dependence, dangerous tolerance, and an inability to sell. The court doesn't need to prove intent to deliver anymore. It only needs to decide what punishment protects the public and best addresses her addiction. Does this radical transparency help her get treatment, or does it convince the judge that only
I'm going to give you inpatient.
sorry.
What I'm saying is that you're not walking out of this courtroom today. Either you're going to be going to prison, or either you're going to be going to inpatient treatment. So it's very important that you be 100% honest with me, because
the line is drawn. You're not walking out of this courtroom today. From this moment on, the only question is which locked door closes behind her prison or inpatient ISF, SAF, P therapeutic community. Defense argues addiction relapse and the need for rehab, and honestly, they're right about the need. But the judge is focused on the pattern, the packaging, and the kids. This is where treatment meets accountability. Question. Should severe addicts be rooted straight to long-term inpatient treatment rather than prison, or is a therapeutic prison community the inevitable route when the facts look this serious?
this is what the court is there anything else for me to say? All right, this is what the court is going to do. I see that she hasn't been to prison before. I'm going to find her guilty, sentence her to 6 years in the prison, the therapeutic community. There's to be no contact with Robert Marble. Give her credit for any time served, and I'll retain jurisdiction.
Okay.
And you can explain to her what that means. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
yes, sir.
Decision made, guilty, 6 years in prison. Placement in the therapeutic community, no contact with Robert Marble. Court retains jurisdiction. That last part is crucial. Retained jurisdiction creates a lane for shock probation. If she does 180 days, follows every rule, stacks up good reports, and engages fully in programming, her lawyer can file to bring her back for a probation reconsideration. Think of it as scared straight with a legal mechanism. Short, intense incarceration aimed to shock the system and pivot her into long-term community supervision. Do you think shock probation strikes the right balance between punishment and...
So here's the thing. When I say that I'm going to retain jurisdiction, what that means is they're going to take you to prison. If you're following the rules at the prison, if you are working on yourself, because they have programs at the prison, your attorney can file a motion. It's called shock probation. Back when I was growing up, they would have scared straight programs. So shock probation is sort of a scared straight program. So hopefully when you go to prison, you will clear your mind.
Yes.
The drug use or the addiction that you have, the craving that you have will be lifted. And if you are doing what you're supposed to do at the prison, if there are no bad reports at the prison, when your attorney comes back for a request for shock probation, I will strongly consider it. So while you're at the prison, you have 180 days. That's when he needs to bring it back before me before that time period. So you're going to do 6 months. And if you are doing well, if there are no write-ups against you, then the court will strongly consider giving you probation. You understand?
Yes, ma'am.
So, well, I mean, these are going to be choices that you make. It's going to be completely up to you whether or not I strongly consider giving you probation. Your attorney will explain it to you further, but any programs that they have at the prison, like the therapeutic community, to address your issue, you need to take it. I know they have parenting classes at the jail. I don't know how long the transfer will be, but you need to take advantage of that. When you see people come before me and they've gone to anger management class, they've done parenting classes, they've availed themselves of everything at the jail and everything at the prison, that is what you need to do. You need to immediately sign up for it. If for some reason there's overcrowding and they don't give it to you, it would be better for you to have signed up for it than to just throw up your hands and say, I'm not trying. Do you understand?
Yes.
And next time, if you have a case before any judge, don't use before coming to court. You understand? But I do appreciate your honesty, but you're going to have to get your life in order. Otherwise, children is going to be without their mom. You understand? All right. Good luck to you.
Summary. The court balanced a possession plea with distribution-like fact 27.459 grams, scale baggies, and vacuum-sealed packaging, plus a fresh positive test on sentencing day. Result: 6 years TDCJ therapeutic community retained jurisdiction, and a 180-day window for shock probation if she proves discipline, sobriety, and full engagement. The judge's message was crystal clear. Honesty is appreciated, but public safety and your kids come first. The takeaway: addiction can explain conduct. It doesn't always excuse risk. Your turn. Was the judge right to deny outpatient and force custody? Does shock probation give her a fair second chance? Or is it too lenient for the quantity and context? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more geo-dropping courtroom breakdowns.